think a little clutter is good. I'm not going to worry about it. I am busy. It's true.
All right, good afternoon to everyone that has already logged on. We're going to give everyone a few minutes to get settled and to log on, and then we will begin the webinar shortly. Thank you. And good afternoon again. If you're still joining us, I see that we have several hundred people already logged on. We're going to give everyone just a couple of minutes to come on to the webinar, and then we'll go ahead and get started. Thank you. Folks, if you joined us, we're going to get started in about 1 minute as everyone has a chance to log on. Thank you. Okay, we're going to go ahead and get started. Good afternoon. My name is Doug Silverstein, and I am the chair of the LACBA litigation section. We are very pleased to bring you this incredibly important and timely webinar today. Demand is huge with over 450 people registered, including many judges. It has become clear that we are unlikely to have in-person civil trials anytime soon. Litigants are therefore faced with two options: indefinite delay or moving forward with a virtual bench trial utilizing video conferencing technology. Conventional wisdom may suggest that being in person is an advantage and that conducting a remote trial would be technically and logistically problematic. Not so. You are going to hear today from plaintiff and defense practitioners who have all handled remote trials, and Judge David Cowan, who has presided over 2 remote trials. You will learn that these proceedings worked extremely well. Very little is lost compared to in-person trials, and there are actually advantages in lower cost, ease of coordinating witnesses, effective instant communications with your team, and real-time access to everything you need for trial that you will hear about in today's webinar. Most importantly, you can actually get a trial date and potentially go to trial in the near term. But there are other important reasons for setting a virtual trial in addition to actually going to trial. We all know that the vast majority of civil trials settle before trial. By actually having a trial date with deadlines for discovery, expert disclosures, and trial preparation, it restores the natural leverages that result in counsel, parties, and insurance carriers' meaningful assessment of a case and resulting settlement discussions. As a plaintiff's employment attorney myself, I have already set several bench trials, including one involving over 50 plaintiffs with significant sums at stake. Virtual trials are the best option to actually move a case forward. Today's webinar will help arm you with information and best practices on how to effectively virtually try a case. Our format today will feature Judge Cowan first presenting the judicial view on virtual bench trials from both the perspective of having presided over 2 virtual trials and their importance in his role as the supervising judge of civil. He will also provide judicial perspective throughout. Each of our speakers will present a topic, and then there will be a panel discussion about that topic. The topics are lights, camera, action, technical requirements, including a virtual demo, virtual trial strategy, and witness examination and documents in a virtual setting. You will have the opportunity to ask questions through the Zoom webinar, and we will try to get to as many of those questions as we can. You also receive the seminar materials, and you'll hear some of the speakers talking about those materials. I would like to personally thank LACBA's Cecilia Gomez, who provided all the back-end support to make this webinar a reality on a very expedited basis. With that, let me introduce our first speaker, Judge David Cowan. With deep experience as a civil litigator at a national firm, a mid-sized firm, and his own firm, and having previously served as the supervising judge of probate and assistant supervising judge of civil, where he had an IC courtroom, Judge Cowan is uniquely qualified to be a leading voice in our court at this time as the supervising judge of civil. I can also tell you that based on working with him closely, he is deeply committed to ensuring that civil trials can and will proceed as quickly and safely as possible. Judge Cowan.
Thank you, Mr. Silverstein, for your kind words, and thank you to LACBA for putting on this important program today. Good afternoon, everybody. I'm really pleased to have this opportunity today to convey 2 principal messages. First, given our current predicament, virtual bench trials may be the surest way this year to provide your clients with their day in court. Second, as a judge who has heard 2 significant trials over a virtual platform, I can vouch that they work very well, can be set up easily, and without significant cost. I strongly urge you to consider taking up this opportunity to provide your clients with this prompt, efficient, and effective way that they can be heard and that the merits of the parties' dispute can be decided. On the first point, we are fortunate in Los Angeles to have an incredible bench. It is a diverse group of talented judges with significant and varied legal and personal experience. My colleagues stand ready to hear these cases. I know myself that when I was able to hear 2 remote trials recently, It was great to be, as it were, back in the saddle again and conducting a trial. Why it is that so many of us wanted to be lawyers and judges. Judges can serve as triers of fact, just like jurors, and provide thorough and thoughtful decisions. We are trained to be impartial and are necessarily committed to giving your clients a fair shot. While we wear black robes to demonstrate adherence to the law, we are also human beings who can hear your clients' stories and render a fair decision that recognizes the significance of the events that we are told about. We need to work together this year at this unprecedented time as partners to keep our civil justice system moving forward and retaining case momentum. Judges, however, cannot do it alone. We need your buy-in to make what is ultimately your court the forum you need it to be. I want us to realize the situation we all now face. To be blunt, if very few trials go forward this year, it will result in a massive backlog of cases. We could end up in the situation that existed when I started to practice, where trials only went forward to avoid the 5-year statute. I want to avoid that problem now before it is too late. As officers of the court, you have a vested interest in making sure that the court can remain a venue that can promptly hear your clients' cases. If at least some trials can now go forward or settle because of a scheduled trial date, judges will have more time to hear jury trials when the pandemic subsides. Though you are keeping us busy with more motions than we were hearing before the pandemic, I think, we nonetheless have time now to hear these trials if we are not conducting jury trials. Judges may also accord bench trials in their discretion some level of priority as a means to manage their inventory of cases. In the typical case, both sides can benefit from going forward now with a bench trial. The plaintiff may have a faster trial date than it would otherwise. In addition, with a firm date, given the vagaries of whether a jury trial can proceed at this time, as Doug said, the leverage associated with that date makes a case more amenable to resolution. We all know that. In turn, defendants can have finality to ongoing uncertainty and the fees that go with a pending case. Wage and hour and PAGA cases are examples of cases that may be amenable to decision in this way. In addition, many contract, declaratory relief, or other equitable cause of action, or matters involving title to real property may also be subject to bifurcating. These parts could be tried by the court first. These alone are a sizable number of our cases. In many of these cases, I suspect the plaintiff might be willing to forego their right to a jury in exchange for not having to wait until 2022, 2023, or even later for their case to be heard. While I know that for many, checking the box for a jury trial on the CMC statement is often done without necessarily that much thought, I ask that you now carefully discuss that issue with your client beforehand and explain the pros and cons. It may be that your client is anxious to have that prompt resolution. I recognize bench trials may not be the solution in all of your cases, or in a case where a very substantial sum may be at play. I'm also in no way intending to minimize your client's right to wait and demand a jury trial. However, I do ask that you and your clients consider this alternative, at least some of them, while we're in this pandemic. This pandemic is definitely not over, unfortunately. I do not hear any official committing that we will be back to normal operations by any specific date. Undoubtedly, we are going to have to keep contending with its fallout for some time, even with the start of vaccinations. Given these unfortunate facts, we should try to make the most of what we have, not allow for matters to become worse by inaction. On the second point, the Los Angeles Superior Court responded swiftly to the pandemic in creating LA Court Connect, or LACC, as a way to hold hearings remotely in conjunction with our case management system and at reduced cost. and we continue to work on its reliability as a video platform. Until that is at an optimal level, however, we are prepared to hold bench trials on platforms that you provide. We have the monitors, webcams, speakers, and internet connection on the bench to conduct virtual trials. All the judge needs is a link to join a virtual platform to conduct a remote trial. Specifically, as to civil bench trials, as opposed to hearings, which we will continue to hear through LACCC, if the parties can provide the judges with their own virtual platform that is ready to go at their own expense with a link in which we can just place a finger, the LA Superior Court will hold a bench trial or evidentiary hearing in this way. As our speakers will discuss today, with the agreement of the parties, this can and is now happening. I say this with the important proviso, however, that you will need to be solely responsible for arranging and supervising the platform, subject to judicial direction. Our staff, who are already working hard, will not be in a position to make the arrangements for virtual trials or to work on technical issues associated with them. The court does not now have the funds to commit to that training. In my experience, however, well-prepared counsel were able to use a virtual trial to put on a flawless technical platform that allowed for an efficient and clear presentation of the facts and argument. It was not cumbersome. There were no connection, audio, or video viewing problems. Neither witnesses nor counsel had to come to the courthouse. There were no travel or health concerns. Exhibits were exchanged beforehand. The court reporter provided a real-time transcript remotely for me to review. I was able to use the 2 computer screens on my bench to see the witness, each counsel, all at different locations, as well as review a blow-up of each exhibit that also allowed for highlighting. In one case, during opening statement, one side also had a demonstrative chart which counsel was able to point to as a useful chronology of key events about which I was about to hear. Cross-examinations were still assisted with the use of deposition transcripts or video clips. I also found that counsel made their examinations more concise in view of the remote presentation that does put a premium on preparation. Similarly, I found there was a greater focus on only calling necessary witnesses. In short, I ask that you give it a try. What you will now hear from my fellow panelists will demonstrate how virtual trials can be just as valuable as one held in a courtroom. Thank you all for your consideration. Doug?
Thank you so much, Judge Cowan. We really appreciate that, especially as the leader of the civil courts. Quick administrative announcement. LACBA has asked me to remind everyone that in order to receive MCLE credit, that you must actually log in from either a smartphone or a tablet or a computer. Simply calling on a phone will not create the necessary record for you to receive CLE credit. Thank you. All right. Our next speaker, John Blumberg, has the rank of advocate in ABOTA. What is perhaps more impressive than the 65 jury trials he has taken to verdict is that he has already tried 3 virtual arbitrations, which have the exact same requirements as a virtual bench trial. He has a lot of great suggestions on how to execute virtual trials seamlessly with a lights, camera, action twist. John?
Well, thanks, Doug, and hello, everybody. Right now, most of us wish we could put on a suit, put our briefcases in the trunk of the car, drive to the courthouse, push open the door to the courtroom, and walk into a room where we would see other lawyers, court clerks, a bailiff or a court attendant, judge on the bench who doesn't have a mask. The courtroom is our stage where we're on display. We can project confidence by our posture, our gestures, the volume of our voice, our physical positioning as we walk around the courtroom. And that's how we've been taught to be effective advocates. But as His Honor just told us, in the short term, maybe for the next 6 to 9 months, maybe more, we have to be able to transition from being great courtroom lawyers to being great video lawyers. Now we can do this, and we can be effective. Even though in video bench trials, we can't use actual physical presence as a component of persuasive advocacy, we can use different skills and different tools to persuade via something like Zoom. Now, one of the benefits of Zoom is that we have some control over our background. So this is not the background where we're going to be. The background where we're going to be may be our office. So here I am in my office. And this is where we're going to be conducting our trials if we agree to the virtual bench trials that Judge Cowan has been talking about. In a video trial, we're seen mostly from the chest up. Essentially, we're a talking head. Now, that's not necessarily a bad thing. Just think about all the influential TV anchors who are talking heads. They're persuasive, and we can be too. They have billions of dollars of media to make them look good. We have to take on that responsibility ourselves. We have to look at a video trial as advocacy with television production values. We all know that persuasion requires credibility. And to be credible, we need to be well-mannered, confident, and competent. Lawyers who have these qualities have an advantage over an opponent who's lacking in those things. This applies to in-person trials. It applies to video trials. I've now handled 3 medical malpractice arbitrations, each one lasting 4 days, which are just like the Zoom bench trials that we now have to become competent to do. My father was a trial lawyer, and he taught me that you learn best from your mistakes. So I've learned pretty well in handling these cases, making mistakes. But he also taught me that it's better to learn from other people's mistakes. So you have that advantage on the back of my mistakes. I think Zoom trial
John might have been. Lost.
Well, we may be having some internet connectivity issues here. Until we get that resolved, we'll circle back with John, but like good trial lawyers, you need to be prepared to deal with something like this. And so what I'd like to do now, so that we don't lose any of our time, is we'll give John an opportunity to come back and finish his incredibly important remarks. I see him logging back on right now. So why don't we go with him right now as soon as he's back up? And it looks like, in fact, he may be up.
All right. Am I back?
You didn't miss a beat, John. Take off from where you were.
Okay. So I was about to talk about contingencies. So let me see if I can remember where I left off. You have to dress as though you're appearing in court and wear a suit with dress shoes and socks rather than sweatpants and bunny slippers. You're going to feel more like an advocate. It's not enough to be good. You also have to look good. Does a good lawyer come into court with scuffed shoes and wearing a badly fitting suit or outfit? No. Why not? It looks bad and it distracts from what we have to say. And in court, does a good lawyer mumble or avoid eye contact? Of course not. A clear, articulate voice and good eye contact are important. In a virtual trial, we're on the TV screen. So to look good and sound good, we need lighting, we need a high quality webcam, we need a good microphone. Don't use whatever was built into your laptop. You will ultimately be sorry, because if your opponent looks better than you do, he or she has the advantage. If you're not in good focus, you're not going to look good. So a high quality webcam is essential. Your monitor should be raised up so that when you position your webcam on the top of your monitor, you'll be looking slightly up and never down. That way, it's going to look and appear as though you're looking right into the camera. If you're looking down at your webcam, then the judge and everybody else will pretty much be looking up your nose. And for most people, that's not going to be attractive. You don't want to be too close to the webcam because you don't want your face to be filling the screen. Nobody wants to see us that close up. But you also don't want to be too far away. You also have to decide how much of yourself you want to show. You want your hands to be seen so you can gesture. Then you have to position your camera so it's low enough so your hands are available to advocate. If your lighting is bad, you'll look bad. If you're facing a window where the light's coming in towards you, that's going to be better than relying on overhead lighting, which creates shadows. If the light's coming through a window that's behind you, that's going to cause backlighting. And what your webcam will do is dim the lens, and all of a sudden you're in the shadows. But even if you've got good natural light, the sun doesn't stay in the same place all day, which means your lighting is going to change as the day goes on and shadows are going to be created. How do you solve this problem? A ring light. It can be positioned on top of your monitor or right behind your monitor, and you can adjust the color and the brightness to make yourself look good and well lit. How about a microphone? Don't use the one in your webcam because you've got to be able to project your voice 2 or 3 feet to where the webcam is, and you're not going to get the clearest sound. So there's 2 kinds of microphones to consider. A standalone mic that you can put on your desk, or a lapel mic. High quality standalone mics are good, but they're going to take up space on your table. My preference is this little guy here. It's a lapel mic, and it just clips onto your suit or to your shirt or your tie, and it turns on. And because it's close to you, you don't get this far away effect. Everything that I've just mentioned about how you need to look good also applies to your witnesses. If they're going to be appearing remotely, then you have to make sure that they know what you now know about how they look and how they sound. Expert witnesses do not assume that they know how to look good on a camera. In court, they walk in, they have all this gravitas on the witness stand. They're not going to have it if they don't look good on the screen. So you have to work with them and your other witnesses beforehand and look on your monitor how they look. You might need to order them a lapel mic, and you might need to instruct them how to position their webcam. Now here's something that we just experienced, internet issues. Your internet connection is really important. And the last thing you want to have is a frozen screen, or, as happened to me a few minutes ago, to lose your connection. The best option is a hardwired connection right into your modem, because Wi-Fi, although it's convenient, it weakens the signal and it can cause problems in reception. You'll get this little label that says you're unstable. And they're not just talking about your personality, they're talking about your internet connection. Also, you have to have a backup plan. As soon as I saw that I had lost the signal, I ran and I got my iPad. It's got cellular connection, and I was about to log back in on my iPad, which doesn't rely on the internet. All of a sudden, the internet came back on and I didn't have to do that. But I was ready, and you have to be ready as well. What about your background? I just showed you a little earlier that this is my virtual office background. It's actually what my office looks like if I had the luxury of being in my office. If you're working from home, what's in your background might not look great, but in Zoom, you can create this virtual background. One tip, virtual backgrounds look the best when you have a green screen behind you, and you can buy a green screen from Amazon that you can just put right behind you, and it really improves the shadows that are created by a virtual background. And all the things I've been talking about, the webcam, the microphone, the ring light, they don't cost very much. Does it matter what you wear? Yes. Like most of you, I have a closet full of great looking patterned and striped shirts and ties, except they aren't great looking on Zoom. Patterns and stripes can cause wavy lines and they can blur on the screen. So it's best to stick with solids. If your socks don't match, that's okay. Nobody's going to see that. So to summarize, pay attention to how you look and sound, because your credibility and ultimately your ability to persuade might depend on it. Thanks.
Thanks so much, John. That was great. We've already got a few questions for you. Are there particular ring lights, lapel mics, and webcams that you recommend?
Yeah, and I don't want to be hawking particular brands. You can get a ring light that costs about $25, $30, and they're pretty much all the same, even though they have different brands. And you just put in ring light for video, and you'll get all kinds of choices. Also, microphones, these little lapel mics. A lot of them are made by the same manufacturers and then just marketed under different names. Anything that costs about $35 or more is probably going to be equal quality. A webcam, I have a Logitech 920, and right after we all went into hibernation here, I tried to order one. And the price was through the roof because now everybody wanted one, but they've started becoming available again. So something made by a reputable webcam manufacturer like Logitech will probably do the trick. But again, don't cheap out. It's not going to be that expensive, but it's really going to pay dividends.
Judge Cowan, we saw that when John lost a little bit of internet connection, he was able to resolve it very quickly. That is something that can happen with virtual trials. From a judicial perspective, is there an understanding that if that happens, that the court and others will be understanding and allow everybody to get back into the virtual setting?
Of course. I mean, I think that any reasonable person is going to give people some leeway in that regard. I mean, I think we probably had it once or twice in the two matters I had. Frankly, at this point, I don't even recall. But it goes with the territory, and I really think that if there's concern out there about that sort of thing, speaking for myself at least, that's the last thing you should worry about. I mean, it's just not an issue, and we all understand it, and we can take a break. It's not the end of the world.
Thank you. There's also a question about the use of virtual backgrounds, that when you move kind of outside of the direct view of the camera, there can be a little bit of flutter or dancing or things like that. What say you about that? Would you recommend not using a virtual background, or how do you address that?
I think certain backgrounds, I joked with Mr. Blumberg before about how many awards he'd got behind based on his different certificates behind him, and so they can be a little bit distracting. So I think you want to be careful about overdoing it. You know, being in look like you're in Hawaii or something is really not. You're in a courtroom. You're not in Hawaii, and so so I think people can overdo it. I think that it's just simplicity is the way to go.
I'd also like to jump in just for a second, Doug, on the virtual backgrounds. And these aren't awards, Your Honor. These are certificates that I got from being admitted in various federal courts. So my trophy room is in another virtual background. Anyway, yeah, the problem with the virtual background is that you can like disappear from the screen if you move too far out. And so you either have to stay put or you get a green screen behind you, and the green screen really remedies a lot of these dancing images. And you can actually get a green screen that you can put on the back of your chair, and then it surrounds you so that you don't get, you know, the kind of fluttering on the sides.
I wanted to share, Judge Michael Linfield is in the audience today, and he shared that as a judge, he tells attorneys appearing before him not to use virtual backgrounds because he finds them distracting for the reasons that we've been talking about. So like most things in the law, there are various opinions about how best to utilize things before the court. Judge Cowan, is there any rule by the court prohibiting the use of virtual backgrounds? Someone asked about that.
Not that I'm aware of, but like I confess, I don't know. I don't know all of the rules, and always like lawyers, we're always got to stay on top of them. But I'm not aware of any rules about that. I think that one thing I would say on a related point is that there's a proposed stipulation that I believe is part of the materials today that is a good form and a good starting point for the kinds of rules and expectations that deal with something like that a judge may want to have, or that the lawyers expect of each other. And so I would recommend people look at that stipulation because it has an amazing amount of good information and things that I wouldn't have never have thought about. So it was put together, I believe, by some judges in Northern California, and I think some people at ABTL, as I understand it. So it's a great start. I think in the two trials I had, all the lawyers used that form, and I don't think they really added that much to it, as I recall. Maybe Mr. Reynolds and Ms. Kayoka, you can chime in, but I thought that was a great starting point for those kinds of novel issues like backdrops.
Great. Well, thank you for that. And thank you, John, for that excellent presentation. So next, we are going to talk about the specific technology that you need in order to effectively put on a virtual trial, including we're also going to see a demo of how a virtual trial platform may actually work. I'd like to introduce two speakers. The first is Tim Reynolds of Paul Hastings. Tim is a business and securities litigator who has already tried a virtual bench trial and will be presenting on the technical aspects of virtual trials. He represents real estate developers and has deep experience in many aspects of security litigation and shareholder disputes. Also, on our 2-for-1 on technology, we're going to hear from Dylan Ruga of Steno. Dylan has prepared a demo for us of what a virtual platform can do. He has a very unique perspective as both a trial attorney who worked at an AmLaw 100 firm, continues to practice, and started a video conferencing platform for legal applications called Steno. Tim, let me turn it over to you.
Thank you, Doug, and thank you all very much for joining this afternoon. I want to echo Judge Cowan's points and Mr. John's points as well, that virtual bench trials are not only feasible, but with the proper planning and preparation, they can be done effectively and even be very cost effective for your clients. So as Judge Cowan mentioned, the court cannot be asked to shoulder any of the additional burden with respect to the technology. They want it to be as seamless as possible, a one-click and work type of functionality, and that's doable. We can put that together. So I want to talk about some of the initial considerations that would go into thinking about that. The virtual courtroom, documents, and then witnesses. And I'll do my best not to repeat some of the things that the key points we've already learned about today. But with respect to the virtual courtroom, we are actually already familiar with these types of platforms. We're joined together today via Zoom, which is a platform that we used in our bench trial that was done 100% remote. We had witnesses in New York, Utah, clients, representatives joining from Chicago, as well as witnesses from around California, all joining us and able to utilize the Zoom platform. And so Zoom is certainly something that we can use as a platform. It requires an application, so you got to check and make sure that the court can function and utilize that program, but it worked seamlessly, as Judge Cowan mentioned a few minutes ago. There are other platforms. Zoom is not the only one out there. WebEx and Microsoft are other examples. And as Dylan Ruga is going to show us, there are also proprietary platforms that vendors have prepared specifically for these virtual bench trials. And Dylan's going to show Steno's platform that is entirely web-based. You get a link sent to you, click on it, and the platform appears. It is similar to the functionality we see here with the squares, Hollywood squares, but also has integrated documents that you can access. And there are other options as well. So there are things out there that you can consider when you are thinking about a virtual bench trial. We mentioned before the video feed, the audio connection, and then separately, lastly, the screens that you would have. And so I won't talk too much about the video and audio connections. Those are critically important, so make sure you have those, and I'll talk a little bit about them with respect to witnesses and preparing your witnesses. But I want to take a minute to talk about your screens. And you need to be thinking about the virtual platform, not just from your presenter perspective, but also from the perspective of the court reporter, and the witnesses. And so thinking about what your screens might look like. When I conducted our remote video trial or a virtual trial, we had one video up front with the screens with the judge, the witness, the court reporter, and opposing counsel on the screen. And then to my left, I had a document screen that it would allow when I was doing a share screen that would pull up the document itself. And you can use the share screen. It's going to be shown later. I don't want to jump the gun there, but you can use the share screen function through Zoom or through another platform. And I had that to my left to use the call outs and being able to see the particular points that you wanted to highlight in your presentation. And then on my right, I had the real-time feed. And so that was my presentation, but knowing that the same wasn't necessarily true for what the witness was seeing and what the judge was seeing. So in considering each of these things, you need to be thinking about how it impacts each person. And really, what I think is going to be weaved throughout all of these presentations today is preparation. Coordinating with opposing counsel, preparing your witnesses, and then coordinating with the court and the court's judicial assistant to make sure that everything runs as smoothly and as seamlessly as possible. So I'll take, for instance, I'm going to dig down a little bit onto witnesses. And now your witnesses for a virtual platform can join us from wherever they might be. For instance, New York was where I had one of my witnesses from. And I wanted to know where was that witness going to be when they were appearing and during their testimony. I thought the best place might be their place of employment. The internet connection would be stronger. I thought they would have a better background, all of the things that John mentioned. When we tested it, it didn't work right. There was a firewall set up, and we knew that they couldn't download the particular application they needed to access. And so we had to think of a new option, and we actually worked it out through the person's home in their apartment. And so we had to troubleshoot that. What external noises might be involved that could impact your audio connection? As John mentioned, it's best to have a separate audio connection, but that's not always an option for witnesses. And so you've got to think through, what audio connection do they have? Best not to use your computer audio, as John mentioned. Best to use a landline or some other remote dial-in. We had everybody use a landline in our case, and it worked seamlessly. And then finally, what I wanted to speak on is with regards to technical assistance during trial. We've already seen some of the technical issues that can arise. And when you think about that, for a lot of things people come to mind is cost, and cost is certainly always a concern. But having a vendor, a third party, facilitate the virtual platform actually can help with operational logistics. And it certainly can be done. And one of our panelists here today has done it without using a third party vendor. So don't let this be a reason not to do it, but engaging a third party to help you with some of these logistics can be really helpful. For instance, sending out the link every morning to the necessary participants is something that has to be done. You've got to send it to the court, make sure that your witnesses have the correct link, and that you are actually logging in and having those things done. The vendor can assist you with doing that initial step. Also, with regards to witnesses, we're used to going out into the lobby and saying, okay, George, you're up next, please come in, and they take the stand. Not the case in our virtual setting. Having the witness be able to join the platform, having a vendor put them into a virtual lobby and test their audio, test their video, make sure that that everything is ready, and then when in the court, when the judge is ready for them, to allow them into the virtual courtroom. And that's something that I think is pretty helpful and critical. And then finally, to handle and troubleshoot technical issues. Inevitably, there are glitches that are going to come up. Having somebody available to troubleshoot those issues and focus on making sure that the technology works properly for you, it can be not only peace of mind, but can help as you're working through, so that there is not something that prevents you from going forward. I'm glad Judge Cowan does not remember, but there was one technical glitch very early on in our matter where one of the videos went dark. And we had the vendor help us assist and troubleshoot to make sure that we were able to get that resolved and it was not a problem going forward. So it's something to keep in mind. And you can shop around. As Dylan's going to show you, there are certain platforms that are wonderful and can put these things together for you. But there are a number of vendors that can do this. So you can ask around and find what might be best for you. I do want to show you, I'm going to turn it over to Dylan now to show you a short video clip for Steno's technology. Dylan?
Thanks, Tim, and hello, everyone. My name is Dylan Ruga. I am a practicing attorney, but I'm here today in my capacity as a co-founder of Steno. Steno is a court reporting agency, a full-service court reporting agency that does everything that other court reporting agencies do. In this context, providing the reporters and the real-time transcripts, as well as some of the technical help that Tim highlighted is necessary for these remote bench trials. Specifically today, though, I'm here to talk to you about Steno's platform, which we call Steno Connect, and talk to you a little bit about how it is used for remote bench trials. There are other options for sure. There are Zoom, WebEx, and others. What makes Steno's different is that we were the only remote bench trial platform that was built specifically for this purpose. We're not just a off-the-shelf platform being used for remote bench trials. We are a platform that was built specifically for remote bench trials. And what that means is you don't need to have separate software to manage exhibits. It could all be done within the platform itself. There is no software to download. As Tim mentioned, some people have restrictions on what software can be downloaded on their devices. Our platform is entirely web-based and can be accessed by anybody with an internet connection and a web browser. And on our platform, we have set up this green room concept that Tim mentioned, where your on-call witnesses can check in with us. We have moderators who are watching not only watching the trial to make sure everything is going smoothly and can help out with any technical issues during the trial, but can also make sure that the next witness who's on deck is present, and we can troubleshoot their technology before they enter the trial, and we can facilitate their introduction from the green room into the trial. So because of time restrictions on this webinar, I can't do a full kind of demo of what a remote bench trial looks like on our platform, but I have prepared a short video which highlights some of these areas and others, and I will show it to you all now. So hopefully you guys were all able to see and hear that. I'm happy to answer any questions as it relates to our platform or any other questions people have about technology and remote bench trials.
Thanks for that, Dylan. Quick question. There's a question, does Steno work with or in place of Zoom, LA Connect, et cetera?
So it's a separate platform, so it would be in place of those other platforms.
And right now, as Judge Cowan mentioned, LA Court Connect does not yet have the capability of doing a virtual trial. So Judge Cowan, in conjunction with court leadership and the administrative offices, has gotten permission for us as attorneys and litigants we represent to be able to utilize these separate platforms, whatever you use, to be able to put on a virtual bench trial.
On a temporary basis while we get LA Court Connect up and running for purposes of a video bench trial, LACC will continue to be the exclusive sole way that people will do remote hearings as opposed to trials, just to be clear.
Dylan, we've had several questions just wanting to know kind of the cost. Can you just very, very briefly tell us what the cost might be?
We have a rate sheet that we can send to anybody who's interested. So you can just reach out. It's dylan@steno.com. So DYLAN@steno.com. And I'm happy to provide rate sheets to anybody who wants one.
Okay, great. We've got a lot of great questions. I want to make sure we give our panelists plenty of time to share their information, because we've really got some great additional information coming your way. So now that you have the technical knowledge and know-how to put on your best virtual trial, let's turn to the substance of a virtual trial. How does virtual trial strategy differ than an in-person trial, and how are they the same? I'd like to next welcome Elise Sanguinetti. Elise is a trial attorney and is one of the few attorneys in the state who has actually conducted a virtual jury trial. She has given virtual trials a tremendous amount of thought. She's a past president of the American Association for Justice, known as AAJ, and a past president of the Consumer Attorneys of California, and has been recognized as one of the top 50 women lawyers in the state for the last 8 years. Elise?
Hi, Doug. Thanks so much. Thanks for having me today. I'm just going to give you a short synopsis of how I came about trying a jury, a virtual jury trial from start to finish, and tell you a little bit about our case and then considerations that you want to have whenever you're conducting any type of trial by a virtual platform. So my trial was up here in Alameda County. I am located in Northern California, although I have an office in LA. And we, my partner, Jamie Goldstein, and I tried a personal injury case that was admitted liability, but disputed causation with extensive dispute about future medical care needs. Our the last offer that we had was a low six-figure offer before trial, and it was our only offer. And then we did a CCP 998 demand for the policy limits. In early December, we had an opportunity to try the case using Zoom from start to finish in Department 517 in Alameda County. And there was no stipulation for us to move forward in that format, but no one objected either. The judge, we were not a preference case, but there was an opportunity for us to be able to move forward and do that jury trial. And we all took that opportunity to do it. It took about 3 weeks for us to try the case, but I will state that was mostly because we had holidays in between. We started actually back in November and finished in the beginning of December. So Thanksgiving and furlough days that was necessary because of the court not having enough funding, obviously, to be able to keep all their employees on, lengthened the trial. But we were still able to conduct this trial, even with those breaks, with a jury, and it went very smoothly. The verdict ended up being, it was nearly 5 times the last demand amount. And we had significant future pain and suffering damages that were awarded. So we were nervous, as a lot of plaintiffs' lawyers I know are, and just lawyers on both sides of the aisle are very concerned about trusting your cases to a different setting. But I want to encourage you to embrace the technology. If you learn how to use it and feel comfortable with it, you can excel. You can do extremely well in a trial. You have the ability to do so. Let me talk to you a little bit about some strategy considerations for trying a case virtually versus in-person trials. So first of all, I believe it was mentioned earlier. I know Tim mentioned it, and I believe John also mentioned it as well, that it is far less expensive to try a case in a virtual setting than it is live. We had clients, our client was not located in the area where our trial was. So she did not have to travel. It was much more convenient for her. The defendant did not have to travel. He was able to appear virtually from his home. Our client's mother is located in Chicago. She was able to testify live virtually from Chicago. Our client's best friend, who lives in Connecticut, was able to testify live virtually without having to fly in. Most significantly, our experts charged us less because they did not have to take out a half day or a full day from their medical practices or from their regular course of business to come and testify and sit in that courtroom waiting to be called. We were able to run the trial much more efficiently and tell them, you're going to just need to block out this particular hour, or maybe 2 hours of your day. And so they charged us by the hour instead of a half day or full day. That was a very significant savings for both sides in this case. The platform, we used Zoom. That was the court's choice. Alameda County actually uses Blue Jeans for their hearings, but for the trials, the setup was just not available to conduct the trial start from finish. Plus, in a jury trial, most significantly, jurors are used to using Zoom. Most of them, if they work from home, that is the platform they're using. If they're not using it for work, they're probably using it for happy hours. So most people are familiar with how to use Zoom. So it was a great platform for us to be able to use because everyone was familiar with it. Now, none of us took for granted that we may have had jurors that were not familiar with the platform. And in your materials that the Bar Association has provided to you, you will see a Zoom info sheet that my office, myself, actually prepared to provide to the jurors and to any of the witnesses that weren't familiar with the platform. And it had some tips in it that maybe most people didn't know, like how to change your views, how to actually change when you're side-by-side view, how to change the size of the side-by-side view so that things could be, so you could make the speaker larger and not just the PowerPoint huge. And I would ask the jurors and the judge to make those changes when I was presenting witnesses or presenting evidence or making opening or closing. So that was very useful. We agreed with the defense counsel. We prepared the draft. They agreed to it. We provided it to the jury and to the witnesses. We did not have to hire, as Tim said, we didn't hire any tech support in our jury trial. We're used to running Trial Director and Trial Pad. We use two different platforms. My partner uses Trial Director. I use Trial Pad. We are used to using those ourselves at trial. It was no different. In fact, it might have been a little easier. It just had to hit share screen. The last trial I did in Los Angeles and Santa Monica, we showed up one day to present a witness, and the connections in the courtroom were no longer working with our computer. So we had a big, we had to delays while we were trying to get tech in there to get things going again. We had zero of those issues during this trial. We played our own videos. It was really easy, and it was just by hitting the share screen. So don't be fearful of the technology. You can learn it, you can embrace it, you can do it. Some other things that are cost savings and that are important. I thought efficiency was much better during a remote trial because it didn't really make a difference if we had live witnesses or recorded testimony. We weren't having to show a video and darken a room. Instead, they were looking at a screen the same way, whether the person was live or whether or not it was through deposition testimony. And the reason I say it was more efficient is that I knew exactly how long that testimony was going to be. We could already work out all of the objections with the judge ahead of time. So it was very efficient. And we could always throw in, if we did have any issues with our live witnesses, any technology issues or availability issues, we could just throw in one of those recorded depositions in testimony. And I wasn't worried about whether or not the jury was going to fall asleep during it. They were paying just as much attention with it not being a dark room as they were when they were watching our live witnesses. Connecting to the trier of fact is something I hear about from people all the time, that since we've done this. How do you connect with the trier of fact when you're doing it in this setting where you're not person to person? I personally felt that it was, especially when I was doing voir dire, which was my best judge for it, that I connected better with the jurors who were my triers of fact than I do in a live jury trial. And that's because I could look at them in the face closer. I could I could manage how they looked on my screen when I had them in gallery view. I had more people that I could have attend trial to watch the jurors when we were selecting them. There was a lot of things that were better. In my particular case, where we did have jurors, I also felt that jury selection, they were much more open. They didn't have as much of a fear of speaking in public. They were in their home setting. They were comfortable. They were more open and conversational with me. It's a little different with a bench trial. That's not as much of a consideration, but there is, you can connect through these platforms in a way that you actually don't have as much of an opportunity to connect when you're live. The jurors, the triers of fact are looking at your witnesses much closer. They can adjust the sound better. They can see what they're showing sometimes better because they can increase the size on their screen. There's a lot of things that can be better for you through a virtual platform. Just a couple of things, because I know that I need to try to wrap this up. Presenting evidence, it's incredibly important, as John mentioned and Tim mentioned as well, that you need to think about what your witnesses look like and what your clients look like in a virtual setting, because there was a stark contrast in our case. We worked with our client to make sure that her background was simple, that she was well lit, didn't take a lot of effort, that you could hear her, that she had a backup set of headphones in case for some reason she had sound issues when she was testifying. The defendant in our particular case, every single day he was not lit from the front. He looked like he was a villain in a movie because you could just see a shadow. It was not a good look for somebody that is a defendant in a case. So you need to be thinking about what your witnesses look like and think about that every single day, and also what they're wearing. Two last points before I wrap up. Opening statement, it was really important. There are disadvantages to a trial being virtual that you need to anticipate, but you can deal with them. It's not 3D, right? So in our case, the size difference between our clients was incredibly important. This was a case where the defendant picked up our client and tripped. It was running with her against her will, tripped and fell and slammed on top of her. And so the size difference between the two of them, she was 100 pounds and 5'2", and he was, here, I'm just going to show you this really fast. He was 6 feet tall and 163 pounds. Because the trier of fact could not see them in real life, we needed to show this in opening, and it ended up being very critical for us in our case. And then, we had to show where her injuries occurred. We also needed to show they couldn't see her, and she had gained 65 pounds as a result of this incident and the injuries that she suffered. And they couldn't see her and tell what a different person she looked like. So we made sure to show pictures that could show the difference in her size before and after this incident occurred. So, so those were incredibly important things. Hold on, let me, hold on, stop sharing. Okay, there we go. So those are considerations you need to make. I also just want to say in closing, when you do a PowerPoint, if you want to have a jury really focus on you, you have to stop sharing your screen to make significant points. That there are times that sharing your screen are important. There are other times in closing argument when you need to make an impassioned speech to somebody, and you need to think about whether or not that's made with a PowerPoint or with your voice and you communicating. Also, the difference between standing and sitting can be very important, and you should mix it up a little bit to make sure that the trier of fact is seeing you change that, because you can use your body to emphasize different points. That is it, Doug. Thank you so much. I hope I didn't take up too much time, but I am happy to answer any questions that people have later.
That was amazing, Elise. Thank you so much for sharing your experience in that regard. We've gotten a lot of fantastic questions. What we're going to do now is move to our next speaker and then take as many questions as we can at the very end. So now that you have some virtual trial strategy ideas, let's get into the nuts and bolts, witnesses and documents. Our next speaker is Lucia Caioca. Lucia handles jury and bench trials, arbitrations, and appeals. She has broad entertainment industry experience, including film investment disputes, accounting disputes, back-end contingent compensation claims, copyright, idea submission, and other intellectual property claims and insurance coverage disputes. Lucia is joined by her colleague, Chris Elliott. Together, they tried a virtual bench trial. Lucia, take it away.
Okay, thank you very much, Doug. And I am going to try, because I know we're running short on time, so I'm going to try to short circuit, I think, some of this and just get through it as quickly as possible. And please let me know if we need to cut it off at any point. So look, the starting point for examining, either by direct or cross-examination, your witnesses in a remote proceeding is basically the same starting point if you were conducting the trial live and in person, and that is your preparation, what comes before. Judge Cowan alluded to the stipulation that likely may be involved if you're going to be doing a remote bench trial. And my colleague, Chris Elliott, actually, who was my guy at the trial that was also running the exhibits, is going to put that up for us because there are some things I want to draw your attention to. I am extremely in awe of Elise that she managed to actually run all of that herself during her proceeding. And I think that's great. And I think it's probably doable. It would take me like 3 years to learn everything, but I think it's doable. Okay, so if you'll see, these kinds of stipulations, this was just as Judge Cowan alluded to, it's something that was put together by the ABTL in Northern California. It's supposed to, and it's intended to cover everything. Our stipulation that we ended up using didn't necessarily adopt each of these, but it was a good starting point to talk about the various things you might have to consider. In terms of, and I do want to mention that business about the remote, the background that you use and whether you can put up a screen, that kind of thing, that actually was addressed in our stipulation. So I do think it's a matter of what does your court want? Does your court permit them? Does your court not permit them? That kind of thing. But the starting point of a stipulation is great because you are going to have to discuss all of this with opposing counsel in terms of what you're going to use. In terms of witnesses and direct and cross-examination, the things that are really, and if we could scroll down here, Chris, to the witnesses and the presentation of testimony, the thing you have to understand is that you're basically needing to meld two things together. You have to meld together what the court typically would require in terms of your witness list and your exhibit list, which is that you would have to submit witness lists in hard copy form, so the court has them. You would have to submit exhibit lists in hard copy form, but then you also have to consider how it is that you're going to be making those exhibits available through the remote setting and what is involved there. And having the stipulation as your starting point so you can work through the issues that you may have about the admonitions that you want the court to be delivering to the witnesses, the exhibit lists, et cetera, is really critical. It's really crucial. Now, a lot of people, and my partners included, said to me in terms of examination of witnesses, whether it's in we've all done a lot of depositions now, but whether it's in deposition or it's in a remote bench trial, what do you do to be able to assure that the witness is not looking at something and being fed testimony and that kind of thing? And really, that is all addressed oftentimes by the court. The court will look and will, first of all, will get some kind of understanding of where the witness is located, and also that the witness is not using any kind of device to look at or receive information from counsel, that kind of thing. And you get their pre-agreement that they're not going to engage in any of those kinds of communications, which is obviously it's important that you have that, because we need to be sure that, you know, our witnesses are testifying just from their own recollection and not being fed questions, et cetera. Now, in terms of questioning witnesses on direct examination, truly, it isn't all that different, except that all those best practices for direct examination of witnesses or cross-examination of witnesses applies with equal, if not more force, when you are doing, when you're questioning a witness through a remote proceeding. So, for example, it's always important that you don't interrupt your witness. It's always important that you have a very focused witness outline and that you know your witness outline. But it's even more important when you are doing this remotely, because frankly, the problem is that the reason it's so important is that there aren't other distractions. When you're live and in person, there's other distractions. The eye can go lots of different places, not just necessarily on the lawyer who is doing the questioning or on the witness. That's not true in a remote proceeding. In a remote proceeding, all eyes are on you or all eyes are on the witness. And so that means it's that much more important for you to be making direct eye contact and trying to engage with the witness as directly as possible without doing a lot of looking down, without a lot of looking away, et cetera. And that is something that you can find maybe a little different than what you're used to. I made a comment during our prep for this, and I want to make it again. And that is that another thing that I thought was a little different in terms of examination of witnesses and taking your guidance from the court is that the court, the judge is going to be sitting in his courtroom. And because he's sitting, or he or she is going to be in the courtroom, and because he or she may be in the courtroom, they're probably likely going to be masked because they do have courtroom attendants with them, et cetera. It's tough. We're all used to trying to read our judge and trying to see, you know, how testimony is landing, how objections are landing, et cetera. When that mask is on, it's a little more difficult to do. So you have to just be very, very attentive and listen very carefully about, so that you are not interrupting the court, so that you are not interrupting your witness, et cetera. That's basically for direct testimony. It's basically do everything that you do as if it were a live proceeding, except just try to pay more attention even to all those best practices that we've all been taught since day one. I want to talk a little bit more about, focus a little more intently though on exhibits, because exhibits are really the key to making your witness testimony work during the proceeding. And if you look at the stipulation, and we don't need to pull it up again because we're running a little short on time, but if you look at the stipulation, you'll see that there's some discussion about how exhibits are going to be presented and how exhibits are going to be handled. You're going to have to do everything that you would do in terms of submission of exhibit lists and submission of exhibits in hard copy form and in the notebooks, et cetera, for the court in all likelihood. You're still going to have to do that. But then in addition to that, you're going to have to decide how it is that you're going to present your exhibit testimony. And both Tim and Dylan alluded to that there's different ways that it can happen. I just wanted to give you an example and show you, for example, the advantages, I think, to the remote proceeding if you're trying to tether a witness's testimony to an exhibit. So for example, if you have a contract, for example, that is a key document in issue, and you want to really draw the witness's attention to particular provisions, you have the ability through screen sharing, obviously, to just simply put it up. And say, for example, there's a key provision in the standard terms and conditions. You can have, you can either do it yourself, or you can have whoever is assisting you with those exhibits pull up the key provisions. And for example, in this setting, the standard terms and conditions was a critical issue, and in particular, approval over changes, production changes with regard to contracts that have been produced. And so, for example, if I'm wanting to focus the witness's attention on this paragraph 6 here, and in particular, that sentence that begins, such production representative will be authorized, et cetera, you have the ability to simply highlight it, call it out. You're asking the witness, okay, now did you Were you aware that you were required to obtain these approvals? Yes, you were. What did you do in order to try to obtain those approvals? And it reinforces the notion that, look, they knew, they were aware, they knew the contract, and they acted in compliance with it. It's all the same things that we would do in live and in person, but you have the ability to do it virtually, and you have the ability to get them to it very quickly. And I think that is, frankly, I think that's an advantage. Now, there is a difference in terms of how you can display and use exhibits. You don't necessarily have to use just exhibit share. And I think it would be beneficial, Chris, if you wouldn't mind, just give us a little bit of a description of the different types of technologies that could be used to share exhibits during a remote bench trial.
Sure, and some of you, I'm sure, have used these probably in the context of depositions. Some services have programs such as Exhibit Share, which are essentially shared folders where the participants can upload the document when it's being used. Everybody can download it. If they need to flip through and see all of the pages of a document, they can do that. You can do that with a proprietary system like Veritex has Exhibit Share. You could also do it with a shared folder program like a Box or a Dropbox. The challenges with that, as opposed to a screen share, of course, is it doesn't give the examining attorney control over what the witness is looking at, and the ability to call out particular parts of a document like we just did. The screen share gives you a lot of options for ability to do that, whether it's using, as we are just using just the PDF viewer and being able to zoom in and highlight. If you need more functionality, you can use something like Trial Director to be able to specifically zoom in on a particular part of a photograph, for instance, circle, do that sort of that capability to really draw attention to the part of the exhibit that you need.
Thanks. And those are very important considerations, frankly, because hearkening back to the stipulation, if you want the ability to be able to highlight or bring forward aspects of documents, you're going to need to get pre-agreement on how those documents are prepared, if they're OCR'd, et cetera, in terms of being able to display them to the best advantage during the remote proceeding. Another issue about exhibits that I think it's important to think about, to talk about, is that, again, pre-agreement on as many exhibits as possible on a joint exhibit list is critical and is key, because if you are in the flow of putting witness testimony on and you're calling up exhibits, to the extent that you have an exhibit that already there's been pre-agreement, you're not going to have to stop and take that break. Typically, we would stop the proceedings. We'd say to the court, can you please look at tab number, blah, 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 in the exhibit notebook, and then try to get some indication as to whether it can come in or it cannot come in. It just makes it a lot more streamlined to the extent that you can reach agreement on the exhibits that can be shown, that can be put up, and that you can just move through it as quickly as possible. So again, it's that trying to do as much prep work as possible before with regard to those exhibits, and agreement on displaying exhibits during the proceeding before it actually begins. I want to talk briefly about cross-examination, because that is probably the key area of concern for trial lawyers. And it's a legitimate one, because cross-examination, as we all know, is somewhat of an art in terms of doing it effectively. And frankly, a lot of us conduct cross-examination using very much our physical presence. And John alluded to this earlier, as have others. And it is an important thing to keep in mind, because what happens on video versus what is happening in person when you're trying to cross-examine a witness are really two different things. And the one thing I want to impress upon people is the importance of getting your setup for cross-examination as comfortable for you as possible. I actually had a conversation with one of my partners who, when they were cross-examining a witness, actually wanted to stand up, because that's how we typically would cross-examine a witness. Our presentation would normally be, we're standing at a podium, we have our witness in front of us, we have our the judge, the judicial officer in front of us, we have our exhibits to the side of us, et cetera. We're very used to that. And it can be a little bit put you off your how you normally are able to convey authority, command attention, if you are simply sitting. And it can replicate very much kind of a deposition type of experience as opposed to cross-examination. And that is not what you want in cross-examination. You want it to be very focused, and you want to have as much command and control over how that witness testimony is coming in. So what do we do in terms of the Zoom setting in order to be able to make that work effectively for us? It's the same thing as we've all been saying throughout, which is that preparation. And it's the same thing as if we were testifying, as if our witnesses were testifying in person, but the need for it is more amplified. So your outline needs to be very focused, and you need to know your outline. You need to know what you want the outcome to be for each of the questions that you are asking. Judge Cowan alluded to it earlier, and I think it is very true. In a remote proceeding or in a video proceeding, you actually streamline your testimony. You don't have, and particularly on cross, you don't want to have a lot of time taken up, which in real time might be acceptable or overlooked in terms of fumbling for a question or a document or the like. You want to be very laser focused when you're on video. And again, it's because there is so much focus on the questioner and the lawyer. And you don't want to be looking down and scrambling through things. You really want to keep it in control as that testimony is coming in. And you want to convey to your the witness that you're cross-examining that you know every aspect of this case, you know where their testimony is going, and you are confident about your ability to be able to get some concession from them while you are cross-examining that witness. And it's a different kind of task when you're doing it remotely on video, as opposed to when you're doing it in person, and you just need to adjust. You need to adjust your questioning style. You need to adjust how you utilize those assets that you have around you, typically in a physical setting, for the remote setting. Can be done, but you have to think about it beforehand. Last, I just want to turn very quickly to the use of exhibits in cross-examination. And not so much exhibits, but also impeachment through the use of other testimony, prior testimonial settings where the witness may have testified about a particular issue or a particular thing. So in a remote bench trial, you have the exact same ability to be able to put up deposition testimony to the extent that you have the opportunity to impeach a witness with regard to their testimony at the trial, if it is contrary to what they testified about previously. And just as in a regular proceeding, you may have the opportunity, if you videotape the witness in deposition, you might be able to do that by videotape. You also may choose to do it just from the transcript itself. Sometimes we as practitioners make the decision in a bench trial or in an arbitration setting that rather than playing videotape deposition, we may simply read from the transcript or have the witness read from the transcript because you want to save time, you want to be efficient and not waste the court's resources, et cetera. There are other times, though, where you may decide it is helpful and useful to put up that deposition testimony by video. And either one is a great option for you. And actually, I think lands a little better in the remote video setting than it does live and in the courtroom. So for example, let's put up the deposition excerpt that we were focused on earlier, Chris. If you have, for example, a case where there is an issue that involves whether or not a witness had a particular conversation with the other side at a point in time, and during the trial, that witness testifies in direct that there was never any such conversation, but you know for a fact that that conversation did occur, you have the ability to put that, not just to read the deposition testimony, but also to put that testimony up before the court so the court can see it. And you can highlight that testimony. So for example, beginning on line 2 and going down to line 4. You can put up specifically the fact that that it was discussed. Did you discuss that directly with, and we've redacted the identifying information, but with Mr. X? And the answer was yes. Well, that's how you testified in your deposition. You testified earlier today that in a completely converse way. Now, what's the reason? You know, why are you changing your testimony now? And you've got the ability to sort of put that up in front of the court, and he is able to read the testimony at the same time as the court is looking at the witness, and the witness is grappling with trying to reconcile the two aspects of the questions that were asked and how they were answered differently in the two different proceedings. And frankly, when it's right there in front of the court, I think it can be a more effective way for that impeachment process to be utilized. Now, we also know, though, that the other way that it can be very effective to potentially to impeach a witness may be through the use of videotape deposition testimony. And frankly, we also all know that it is advantageous to put up witness testimony, video witness testimony for other purposes. It may not just be for impeachment purposes. But for example, if you have an issue where the question of whether a witness has traveled to another country, for example, Australia, if that's a key issue, and you want to highlight the difference between the testimony at trial versus in deposition, you might do something like this that's going to have a corollary beneficiary effect as well.
Remember earlier today when I asked you?
No.
Why don't you listen to what I had to say first? And then maybe you'll tell me yes or no.
I don't have to listen to anything you have to say.
Clarify my question. If you have a question about my question,
Today is not
you have
for
the
you
right to be
speak over
clear
me.
for you to be able to be
Mr.
clear.
Child.
You remember being in Australia ever?
I don't know if I've been to Australia. I've been to Australia?
So we put that up. Obviously, that is a very famous deposition excerpt that it's made its rounds on a lot of the entertainment shows, news shows. But to make the case that it is just as easy to put up that video clip, and in fact may even be more impactful if you use it in that kind of setting through the playing of the video on the computer screen so that the court can take a look at it. Okay, thanks very much. That's about everything I wanted to cover. Thanks, Doug.
Great. Thank you so much for that, Lucia and Chris. Great information. We do have a number of questions, so let's see if we can spend a few minutes answering some of those questions. We've had a number of questions, and let me open this up to the entire panel, including Judge Cowan, of course. We've had a number of questions about possible witness coaching in a remote setting or other people being in the room with the witness. How is that addressed through a virtual trial?
This is a new world, and so if I don't get everything, forgive me. But one thing that I tried to do as a practice is at the beginning of when the clerk swore in the witness, I would always ask, where is the witness speaking from? We've heard that sometimes can be in different countries or different parts of the country, and so I just wanted to have that information, because in one of the cases, they were in the same room, the lawyer and the witness. And so I was certainly not aware of any coaching or the like. Don't believe there was, but it was relevant to me to know that they were in the same room. People can, by looking at one another, convey a lot of information without saying anything, without a kick under the table. There can be dynamics there so just knowing where people are, who else is present, I think is something important to be aware of. But I think, how do you stop people from communicating by a text with that client is an open question. I think it's good to be sensitive to that, and I think that the law will I'm sure that the tech people, the law, we will figure out a way to address those. That's really all I can say at this point. But it's a tricky concern.
Judge Cowan, another question for you is, how do you manage objections remotely?
I try to do them the same way, just like the lawyers put on the cases the same way. The court rules on the objections the same way. I think having the real-time transcript is often very helpful. To be honest, in some ways things slow down a little bit, so it actually gives me a few more minutes to have an opportunity to make sure I'm making the right evidentiary ruling by looking at the transcript. Because sometimes we can all have moments where we're more focused and less focused. So having the transcript, the real-time testimony in front of you to me is very helpful.
Okay. Opening it up to the entire panel, how do you deal with witnesses who are either older or unable to access or use Zoom or other electronic means without help? Yeah.
Well, I can jump in on that one. Sometimes you've just got to, if you're able to, bring them into your office under the best protocols that you can. I had to do that with one of my witnesses who just was unable to figure it out. And I have a glass front conference room. And so I set the witness up in the conference room with a laptop, and I was on the other side of the glass. And so they were able just to come in and be able to testify without having to worry about any of that stuff. Otherwise, if they can't do that, then you've got to hope that they have a fourth grader around who can help them.
Lucia, did you want to add something to that?
Yeah, I was just going to indicate that we actually were very concerned about that prior to our proceeding. And one of the advantages of using a vendor was that we did have the vendor work through with each of the witnesses on both sides to make sure that they had the right equipment, that they had the right internet speed and everything to make everything work. And we actually considered and we're testing out, okay, would it be better if we conducted this from our offices and put everybody in the, the glass conference rooms, or at least counsel and our support. But we actually found that it was kind of along the lines of, I think what Tim had indicated, it actually worked better if we had everybody in their own setting and we just worked through it and coached everybody through it prior to day of testimony, how to get it so that it could work for them. They may not have the equipment, you might have to send them things, but you can usually get them up and running if you spend enough time prepping and coaching beforehand.
Great. All right, there have been several questions about how you subpoena, asking them to appear, cooperative.
You were cutting out a little bit, Doug, but I saw those questions in the Q&A, and I can tell you for our trial, we did it the same way we usually do it, and Judge Cowan, I'm sure, can talk about how it's being done in LA, but we just subpoenaed them to the courtroom on the first day of trial, and then we worked out with the witnesses the time that they would need to appear and the manner they would need to appear.
That's right. That's what we did as well. To the extent it was necessary, the parties did that in our situation. And then you've got to coordinate. You've got to communicate with witnesses and work that out, because those are certain things you've got to address, and better to address them up front than during trial.
I think I would say that the importance of civility and working with one another as lawyers is critical in, as always, but particularly here. Speaking for myself, if I see people are not cooperating and that with kind of basic things like this, it really does not help. And so it really pays that, this is not about arguing about little things. If you want to have your client's cases heard, let's cut through the details work this stuff out, and we can hear the merits of your client's disputes. So, really working with one another being uncooperative does not help. It hurts. And so I would make a pitch that that as lawyers, it's really critical that you work together in these instances. My experience was that people do, and I encourage you to continue to do so.
If a third-party witness is subpoenaed, are they using their own equipment, or are they using equipment provided by the subpoenaing party?
In our case, our third-party witnesses use their own equipment, but we would have provided them with Chromebooks if they're so inexpensive. We would have just sent them equipment if we needed to.
Here's an interesting question. Are the costs of a third-party virtual platform a recoverable cost?
To be determined.
Yeah, my take on that is the only things that are recoverable costs are those that are in 1033.5. Although I think that the court has discretion if for example, I know that the court has discretion to decide whether the tech services, for projecting stuff during a trial are recoverable. So it may very well be in the discretion of the court.
Doug, in our case, we didn't have any costs associated with it because it was through Zoom and the court provided it, but and we have already submitted our costs for consideration, but I definitely would have claimed if I had used an outside vendor that it was necessary for trial, as a cost related to trial. So I definitely would have put it on there.
I mean, this seems like it would be an absolutely necessary cost because you're not having a virtual trial unless you have virtual capabilities. And then it's a question of what amount is the recoverable cost given varying platforms. So I think that's an interesting issue. And this is an example of how the new technology and the new reality is kind of leading to areas of the law that have to be confronted that perhaps haven't previously been confronted. Here's another good question. Is it possible to sit in on a virtual bench trial?
Can you say that question again?
Sure. Is it possible to sit in on a virtual bench trial?
It's important for the court and everybody remember it's still a public proceeding. And I believe in one of the two cases, there was some media interest in the case, and they did attend and listened in on the proceeding. And so these are not private proceedings, obviously, and the court did provide access to third persons, even though, and they were advised, of course, that they could not record what was occurring, but it is a public proceeding, even though it's virtual.
And in Alameda County, where we tried our case, they had a radio broadcast that they have available for trials. And that radio broadcast was listening in on our Zoom jury trial, but it did help to prevent from having any Zoom bombers or unanticipated interference with our trial by having to go through that process. I don't see Doug anymore.
Oh no, we lost.
Can you guys hear me okay?
Yes.
We can hear you.
This evidence is why you might have tech support in your virtual bench trial to support with some of these issues. But
Maybe we should just take one more question since we can all see them and just put it out there while Doug is trying to come back on. How about, is there an effective way to exclude a witness who is sharing the same computer with another witness, both of whose testimony is necessary, but where the attorney wishes to keep their respective testimonies separate and excluded from each other? Would anybody like to take that one?
Let's pass the lunch hour. I think that's too complicated.
I think perhaps my
Okay.
panelists will disagree that the most important thing is trying to keep everybody on separate devices so that you can keep everyone separate from each other in terms of the testimonies that's coming in. I could be wrong, but that would be my sense of it.
You know, one of the things that that came to my mind when we were talking about how do you, if people don't have their own equipment, that sort of thing. If you have a court reporter that you're using for the procedure, a lot of court reporting services have the ability to, have the setups where they can have a witness come in to their facility and it's all set up. And so that may be one of the things that can be negotiated between counsel, that the court reporter can provide that service, not the court reporter, but the reporting service.
I'll just say on behalf of Steno, that is a service that we provide, but rather than having people come to our office into a room, we'll just send them whatever equipment they need, whether that's a 4G loaded iPad or a tablet or whatever it is, so that they can connect, from wherever they are. Particularly in this COVID kind of era, we don't need people traveling to our office in order to get on. So whatever technology is necessary, we're happy to provide it.
All right, great. I made it back on, and we definitely overcome all technological issues. I want to sincerely thank all of today's panelists, especially Judge Cowan. Everyone put in a tremendous amount of time to make this such an outstanding webinar. And I think we went a little bit longer, but the information was so good and there were so many questions. I know we wanted to make sure that we were receptive to the audience to be able to provide as much information as possible. So this is a great option. Bring it up with your particular judge. That's who rules the roost in that courtroom and makes decisions about all of this. And so this really is a great option to be able to move your trial forward. So with that, we're going to wrap up the broadcast portion of this. And if the panelists could just stay on for a minute, I want to thank everyone. Cecilia, if you could just let us know when it's just the panelist.
Yes, sir.